There's been a lot of talk about the Byrds with the HPA and Short Act, especially now that it's going on to the Senate. But we all know that the Byrds aren't real, but the Byrd Rule is. Stick around as I explain what the Byrd Rule is and why it matters for getting suppressors and short-barreled firearms off the National Firearms Act. Hi, I'm Ben Sanderson and you're watching the Minuteman Moment. But before we get into the video, I wanted to take a second to let you know about GOA's annual convention, Goals. The Gun Owner Advocacy and Leadership Summit is set to be held August 9th and 10th of this year in Knoxville, Tennessee. Come out and visit with some of your favorite manufacturers, participate in activism training, and hear from the top voices in the Second Amendment community. The best part? It's free for GOA members. So sign up today using the link in the description below. Okay, now back to the video. With the House passing their version of the Budget Reconciliation Bill, aka the Big Beautiful Bill, it's time to talk about what to expect in the Senate. Currently, the House version of the bill only includes the Constitutional Hearing Protection Act, which deregulates suppressors. But GOA is also pushing for the Senate to include the Short Act, which would remove SBRs, SBSs, and AOWs from the NFA, protecting short-barreled firearms like pistol-braced ARs. We're working with our allies in the Senate, like Senator Crapo and Senator Marshall, to add the Short Act to the Senate version of the bill when they start their bill process in the next few weeks. And in case you missed our previous videos on budget reconciliation, this is our best opportunity to win major pro-gun victories and deal a blow to the NFA because the bill can't be filibustered, meaning it only takes 51 votes to pass in the Senate. The other quirk of this bill is that everything added to the bill must be budget related. And you might be asking, how do we decide if something is related to the budget? Well, that's where the Byrd Rule comes in. The Byrd Rule is a Senate-specific procedure that allows a senator to question whether or not bill text is relevant to budgetary changes. This is also known as raising a point of order. This process allows senators to remove text if it is not relevant to the bill. But who decides whether or not the text is relevant? That would be up to the Senate parliamentarian, a bureaucrat whose job it is to make rulings on the relevancy of the text. But it's not just an arbitrary decision. There are 5 relevant tests for whether or not the language is okay or not okay under the Byrd Rule. These tests come from federal law under Section 644 of Title II USC. To make it a bit easier to understand, I'll walk you through how the Short Act complies with all of these tests laid out in federal law. The first rule is that the provision must change how the government spends or receives money, aka if a bill has no impact on taxes or the budget, then is not primarily a budgetary item and cannot be placed into the Budget Reconciliation Bill. The Short Act passes this first test with flying colors because its primary focus is on removing short-barreled firearms from the National Firearms Act, which reduced the government's tax income on these firearms from $200 to $0. GOA worked with members of Congress to get this scored so we could prove this point to other members of Congress. The Joint Committee on Taxation said that the Short Act would cost about $295 million in lost tax revenue over the next 10 years. The real kicker was the score on the Constitutional Hearing Protection Act for suppressors, which would cost about $1.8 billion. Now, that might seem like a lot of lost revenue, but it's completely unethical and unconstitutional to tax a constitutional right like that. The tax has got to go. And if anyone in Washington tries to tell you that $2 billion in lost unconstitutional gun control taxes is too expensive, then ask them why they always seem happy spending trillions of dollars on other priorities. The next test is the committee instructions in the bill. Before the bill is written, congressional committees are given instruction on who's doing what and how much money they can spend. This means that if the Judiciary Committee was told not to include anything in the bill, but they tried to push through a bunch of tax cuts, that would fail, because even though their items were budgetary focused, the committee is not allowed to include anything. Luckily, President Trump wanted to focus on tax cuts, and we wanted to deal with the NFA tax, so the tax committees got their instructions. The third test is that a committee, even if given instructions, cannot include something that is outside the scope of their jurisdiction. In the case of the Short Act, while it might seem as though this would be under the Judiciary Committee since it relates to gun laws, it's actually under the House Ways and Means Committee and the Senate Finance Committee. These are the tax committees, and every year when the Hearing Protection Act and the Short Act get introduced, the parliamentarian refers our bills to these committees. So, it's their job to include this language in their sections of the bill. The fourth test is that the deficit cannot increase beyond the instructions given at the beginning. This means that if the resolution says that the deficit for over 10 years is $1 trillion for the Judiciary Committee, the committee cannot spend over that amount over the next 10 years. Now, this doesn't affect the Short Act on its own, but is more relevant to the larger Finance Committee bill itself. Finally, the most important test is that the change in spending and receiving cannot be merely incidental to the policy outcome. This is often referred to as the merely incidental test, and most often when people say that a bill fails the Byrd Rule for being a policy, this is what they mean. In short, the merely incidental test means that the primary focus of the language you want to pass must be the money coming in or out of the federal government. And It means that you cannot just force a major policy through by including a small budgetary or tax mechanism. Now, this is a major reason why we chose the SHORT Act and the HBA as our bills to push through the budget reconciliation process, because banning red flag laws or pushing concealed carry reciprocity would not be primarily budget focused. It's important to also realize that excise taxes like the NFA have also routinely been amended or struck entirely by previous budget reconciliation bills, and this bill is no different. So don't let anyone tell you that it's okay to strike a federal excise tax on tanning salon beds in reconciliation, but not okay to strike the federal excise tax on suppressors and short-barreled firearms. Now, I've talked a lot about the NFA being a tax, but don't just take my word for it. You can listen to the Supreme Court say exactly that in the case Sonzinski versus United States. SCOTUS said in 1937, just 3 years after the NFA was signed into law, that on its face, the National Firearms Act of 1934 is only a taxing measure. They also said, every tax is in some measure regulatory, but a tax is not any less a tax because it has a regulatory effect, and has long been established that an act of Congress which on its face purports to be an exercise of the taxing power is not any the less so because the tax is burdensome or tends to restrict or suppress the thing taxed. And having a required payment of a transfer tax and registration as an aid in collection of that tax, Congress under the taxing power may reasonably impose a penalty on possession of an unregistered firearm. Clearly, the Supreme Court believes in Sonzinski that not only is the NFA a tax, but also that Congress is well within their power to tax firearms and punish those who don't pay their taxes. The reason the NFA has been upheld as constitutional for so long by so many different courts is that because those courts don't see it as primarily being against the Second Amendment. Instead, the courts view the NFA as Congress taxing the ownership of these specific firearms. This view is exactly what's going to help us remove suppressors and short-barreled firearms from the NFA, as it is primarily a tax and it's part of Congress's power to decide taxes. Other federal courts have also upheld this interpretation as well. Additionally, all the fingerprinting, the photo ID that you have to submit, and the $200 tax stamp are all part of the tax collection process. Essentially, those forms are all tax forms. So, to wrap it all up, we have two bills that focus on undoing gun control that the Supreme Court and other federal courts have said are a tax on a tax-specific bill, and these bills also pass the tax test for the bill. But there are other parts of the Hearing Protection Act and SHORT Act which aren't so clearly budgetary. But it's still important to put these provisions into the bill because they are necessary in conforming to the Byrd-compliant language. For example, there's an odd requirement that SBR and SBS owners get permission from the Attorney General to transport their firearms across state lines, which would be incredibly difficult for the federal government to even enforce if short-barreled firearms are taken out of the NFA. And on HPA, if we don't specify that mere possession of a suppressor is compliance with federal NFA registration requirements, then gun owners in states like Michigan, Colorado, and several others may end up with legal issues because of their state statutes. The reality is, we're never going to get all 50 state laws in a good spot before we can repeal the NFA, especially states where their state possession laws are dependent on the unconstitutional NFA registration. We have to take this opportunity to get rid of the NFA that's before us. In fact, GOA's draft language that we circulated earlier this month and have been working on for the past year has always included protection for gun owners in these states. Adding in the gun owner protection language would also comply with the rules of the budget reconciliation process because 1, they are necessary to help implement the larger goal of deregulating short-barreled firearms and suppressors, and 2, are not the primary focus of the bill. So even though these conforming amendments, as they are called, are not budgetary related, they would still be acceptable under the Byrd Rule. That's why we need pro-gun senators to argue under the Byrd Rule that such protections are necessary and conforming amendments. These are also allowed, someone just has to make the right argument to the parliamentarian. But we shouldn't also let members of Congress tell us why the Byrd Rule won't allow us to do X or Y. We didn't with Representative Kustoff, and we shouldn't do with the full Hearing Protection Act either. Because the way the Byrd Rule works is that not anything that violates it is automatically struck from the bill. If something violates the Byrd Rule, a senator can raise a point of order, then the parliamentarian will rule on that point of order. And then it will be struck from the bill if it violates that point of order, unless a simple majority of senators overruled the parliamentarian. So, the pro-gun senators should put every protection for the Second Amendment possible into the reconciliation bill. And if the anti-gun Democrats truly are so evil, let them raise the point of order. And if the parliamentarian rules with the anti-gunners and doesn't think that it's necessary to protect gun owners in these select states, the senator should vote to overturn the parliamentarian because it is clearly necessary to protect the right to own suppressors while taking suppressors out of the National Firearms Act. Also, just so everyone knows, there may be legal arguments we can make or rule changes by the Trump administration that could potentially help suppressor owners in these states if Congress fails to do so. But we shouldn't give up the fight now. Gun Owners America has always supported putting the full protections of the Hearing Protection Act and Short Act into the big beautiful bill. But it's not going to happen all on its own. I can tell you that the federal lobbying team is hard at work here in DC, but you can join the fight too by calling your senators at 202-224-3121 and encouraging them to support the HBA and the Short Act in the upcoming budget reconciliation bill. Now thanks for watching. Be sure to like, comment, and subscribe to stay up to date with GOA's latest fights for your rights.